Welcome back to the news at 6. The law states that you're innocent until proven guilty, but in a case where a guilty verdict seems obvious, when should a defense attorney advise the client to take the guilty plea and avoid a trial? Well, here to weigh on that subject is our legal guru, attorney Jay Davis. Good evening, Jay. Thanks for joining us.
It's good to be here.
So we've got some situations, obviously the Boston Marathon bombing, the sentencing trial or the sentencing phase is going on right now. We've got the case with the man flew a helicopter over onto the Capitol grounds to deliver letters to Congress, and then even more locally, Atlanta public schools, the cheating scandals where the teachers are pretty much caught red-handed making these test changes. So when it comes to cases like this where it just seems like the defendant is guilty, when should an attorney take that plea or advise their client to possibly consider something like that?
Well, the first thing you have to do as a defense attorney is you have to be good at negotiating a plea. The way to be good at negotiating a plea is to actually have trial so that you challenge the evidence that the state is presenting. That's what makes you able to work the next time with the prosecutor, whoever it might be, a DA or solicitor, to make sure that they believe that they know there's a risk by going up against you. So sometimes you try to make that defense. But when something is obvious like this, the first thing you're going to do, if you believe that all of the evidence is against your client and that he or she is likely to be found guilty in a trial, then you want to negotiate for the best sort of that might be available to that client. In the case of the helicopter, for example, there might be some psychological issues going on. So you need somebody to examine to see if this is some sort of a defense. That maybe the defense isn't did you do the act, but was there some other underlying circumstance that may explain why you did the act, and if so, would that lessen or reduce what you might be culpable of?
So it could essentially looking for another way to maybe explain what happened and to get if it does go to trial so the jury could accept it.
Right, you find other things. You find other things that may be palatable to a jury. You think about who your jury is likely to be, what they're likely to listen to. You know, there's a lot of things going on. There's undercurrents that are going on in our country today. So if there's racial issues that are similar to what's going on, if there's a feel of what's going on with juries and what's going on with the average citizen that maybe the prosecutor is not necessarily aware of, that as a defense attorney you feel like you could convey and say, hey, there is a defense to my client, there is legitimation, especially in self-defense acts or when somebody acts irrational for some reason that you can show the jury where that was coming from. Sometimes those things can create defenses that you might not see early on. But if you can't get the prosecutor to get right on a plea, then you do go to trial generally just to make them prove their case, and then sometimes you get you get out information at that point that may help you in your sentencing phase so that you might get a better sentence in the end.
All right, thank you so much, Jay. Appreciate your time as always. And we want to hear from you guys. If you have any legal questions, email us at itsthelaw@41nbc.com. We'll do our best to answer it during our It's the Law segment right here during the news at 6.